Hi everyone, welcome. We're doing our weekly live Q&A session with John Khosravi. Let me turn on my secondary camera to make sure everything is good and working. Please excuse the delay. Let's see, that's up and running. So just to come back again, welcome everybody. I'm John Khosravi. Thank you for joining us. JQK Law Firm's weekly Q&A session, taking your questions for general education purposes. Every Wednesday, 5 p.m. Pacific time, we're here. It's a half-hour show. We're coming in 10 minutes early. We do that a lot just to get more questions in. The fun part is we have multiple free raffle giveaways. And the giveaway for those watching live is a free 15-minute consultation by video, 15-minute. Every 10 minutes or so, my associate will, pick a random person that likes, subscribes on the various social media channels that we're posting, and lists, that they want a free consultation, and we'll choose that person. We'll give away free 15-minute consultations today. So definitely just like, subscribe, and leave a comment that you like that consultation, and we'll take it from there for those watching live. Now, there's a lot of immigration changes in the news right now in late July. I want to share. They're all over the place, but most of them are pretty good. So the first one I want to start with is the fact that it's a mixed bag one, that employment authorization cards, work permits, for those who file for adjustment of status. This is if you're filing for a green card from within the United States. You file for adjustment of status. With that, you could file Form I-765 for an employment authorization document, EAD for short, or work permit as we all call it. They're going to give those for a 2-year period of time instead of 1 year as they're doing. So it sounds kind of good. Okay, they give you a full 2 year, but the backhanded part of it is the reason why they give 2 years is because it seems they're going to be expecting a lot of delays in adjudicating and deciding these green card cases. So they're giving you 2 years of work permit time ahead of time so that you don't have to refile, create more work for them. It's a mixed bag. It seems good. On the positive side, the massive delays and amount of work coming into USCIS has caused them to start thinking things a little better. One example is that for student visa people applying for student visa status in the United States. So if you're in the United States, for example, on a tourist visa, a B1, or more likely a B2 tourist visa, usually get 6 months on that. If you come in and then change your mind and decide to actually stay and go to school, what you had to do previously was file a Form I-539 and request a change of status to student status. But also, you have to file another Form I-539, pay additional fee, and request an extension of your tourist visa at the same time. So, tourist visa status at the same time. Now, it's very confusing, and a lot of people who would file these cases on their own weren't aware that you have to submit 2 applications for some reason. One to extend the tourist status, one to change from a tourist status to a student visa status. Didn't make much sense. It was unclear in the instructions. Many people got horribly hit by improperly filing these. But hey, that's the situation. They finally said you don't need to file these bridge B2s anymore. You could file the F1. Now, the solution they had still has issues and inconsistencies that we're trying to word out, but I just want to give you a heads up that that's one of the positive cases. On the negative side, going from positive to negative, is deferred action for child arrivals. This is DACA, the Dreamers. These are people who came to the United States as young children, and President Obama started a program where they could, at least stay here without threat of deportation removal if they've had, a proper situation. If they've had no criminal history and anything like that, they'll get a work permit. Well, a judge in Texas said, no, this program is illegal and they won't allow it. So the consequence of that is they'll let the people who had DACA continue it, but no new filings are possible. And so the people who have submitted it since it went away under Trump, it came back. Those new ones that started initially when they came back, they will not be accepted. The biometrics appointments are being canceled. In those cases, they're going to be sent back. So that's a negative news. But if you had DACA and you want to do advanced parole for it, those are still going on. In the news, it was reported that these cases, because so many people filed for DACA in this few months that they had, USCIS got overwhelmed, and the processing times for this got horribly delayed and out of control. And so maybe now that they're going to stop adjudicating those, they'll create more time to adjudicate the advanced parole cases. People who were here on DACA needed to travel for emergency purposes. Those are taking 3 to 6 months, 6 months easy. Hopefully, those become a little faster. And so there's other stuff too, keeping the bad news alive. The Department of State, these are the people who handle the embassy system. They have a website that they update now every month that says how many cases are in the backlog to getting an embassy interview. Now, typically in 2019, this time before the pandemic started, there'll be 50 or 60,000 cases waiting to have an embassy appointment in the 100 embassies that are in the world. But right now, the shock, be prepared, trigger warning, 500,000 plus cases in backlog to have their embassy appointments. It's wild. So that's a situation dealing with. They're telling us that's the situation. And so, that's what we have to deal with right now. So if you are outside the United States, expect continued delays on getting the immigrant visa interview, even a regular interview for a non-immigrant visa, tourist visa, and stuff like that. Those are pretty much shut down for a lot of places. So that's the news with regards to immigration, late July, or 3 quarters in of 2021. But with that, let's get the show started. All right, so our first question is coming from Tara. Can you explain about the E2 visa? Sure, E2 visa is a wonderful visa. I wish there was more of it. But essentially, it says this: if the United States has an agreement with the foreign country, and you're a person from that foreign country with a passport of that country, you could come and start a business in the United States. There's no minimum investment. The investment amount just has to be enough to make a case viable, to make sure it's realistic. It's not like you're starting a factory, a car factory with $10,000. That wouldn't make sense. The money invested has to make sense with the work that's being done and the company that's being created, or sometimes you're being employees from the home country as well. And so the one issue is you have to invest the money first, for the most part, a majority of it at least, to and put it at risk, and then file for the visa. And the visa is denied, you may lose out on that money. So that's a dangerous aspect of it. But it's a great program. You definitely need to consult an immigration attorney to see what's going on, so if it's appropriate or not. But it's an investor program. The first thing you do in this kind of case for an E2 is you see if the country you have a passport from, and some people have multiple passports, is this country on the E2 treaty list with the United States? Is there a treaty for this visa category? If there is, you can take it forward. Most of the big countries in the world, India, China, Russia, Brazil, they do not have the E2 treaty with the United States, so that is going to be problematic. We can't use it. But we have a lot of Brazilians, for example, who also have Italian citizenship, Spanish citizenship, French citizenship. If they get the passport from that country and they apply through that, it is possible to the E2. There's a lot of nuances we can't get into here as case specific. But other than that, the main thing to know is, yeah, it's possible. Just gotta look into it, talk with an immigration attorney, and see how they can help you on that. All right, next question. Oluwartimi, one of our regulars, says, good evening, sir. I hope you and your family well. God bless you, Oluwartimi. Good to talk with you again. And ask, I'm an American citizen. Can I file for my mother-in-law? My wife's mother's in Haiti because my wife has a green card. Will it be faster? Thank you. Well, no, unfortunately. To be able to apply for a parent, you have to be the child. So you could file for your parents if they're overseas, but your wife would need to file for her parents. But because she has a green card, she can't apply for her parents. You can't do it as a son-in-law, unfortunately. So you have to wait a little longer. Your wife has to get her citizenship as soon as possible. And what I do in these kind of cases is, for my clients, I have the case prepped ahead of time so that as soon as you get the naturalization certificate, you file that citizenship case. File the green card case for the parent, so you hurry it up. But Haiti's backlog and they're not processing cases. It's going to be a while before this could happen. Sharing and Caring asks, hi, sir, how are you? I want to know this month I want to submit the M400, the citizenship case, while my I-751 is pending. That's removal of conditions. That's when you have a green card. That's a 2-year green card. You want to get a 10-year green card because they want to check to see if your marriage is real. So the I-751 was pending. Is it better to submit request letter to adjudicate my I-751 and M400 together? I need your help and service. Well, you can't request anything. What happens is, if you have an I-751 pending and you apply for an N400, they're supposed to put it together. That's what USCIS has done. They put it together and they try to adjudicate it later on. They don't always do that. You don't have any control over the situation. So just submit your N400 and then see what they do. They should know that you have an I-751 pending. It's really easy for them to look up. They'll see your green card is already expired. So, you just got to do your part, file a case when it's appropriate, and then hope for the best, and hopefully it doesn't take too long. Patrick asks, what is the most common question for marriage interview, and what's the main important thing that we should work on to get accepted? It's a difficult question to ask. You should download my guide, the Ultimate Marriage Green Card Guide. It really goes over all of this. It's 40 pages, and that's not even enough. So if you want a good answer, go read the 40 pages there. Go to marriageimmigrationlaw.com to get it. But if you're looking at an aspect of it, they're going to check into your relationship and they'll ask questions about your relationship timeline. When you met exactly, like March 5th. Not just say, I met sometime in 2017. You don't know the details. Where did you go afterwards? You got to know the details of your relationship and to be able to go through it. That's one of the main things I'm seeing them asking a lot recently. So that's something you got to do. And, work accepted. I mean, there's a lot of different aspects. There's, your civil documents, the history of the applicant, and whether a petition was properly filed. So there's a lot going on there. But main thing is just know your relationship history in detail. And you might say, oh, that's dumb, or who's going to ask this kind of stuff? They do. They go deep into it sometimes. So you got to be prepared. Now, I want to announce our winner of the raffle is Caring Vlogs. Thank you so much for participating. Please take a screenshot of wherever you're seeing this video so I can see your username there, and that's yours. And email that to me at info@jqqlaw.com, info@jqqlaw.com. And I'll reply with a link to do a live video chat together. I look forward to it. Now, one thing is we're getting questions as usual about timelines, how long things take. I don't have answers for this stuff. Most of the time, it's not even possible to give an answer. Other times, the very few other times I may have an answer. I need to do a lot of research into your case to see what's going on first. And at the same time, whatever I say could be wrong because the timelines are inconsistent. So I want to leave that when it comes to how long things will take. And I already mentioned it before, but please do download the Ultimate Marriage Green Card Guide. If you're thinking about getting a green card, and if you're not getting a green card through marriage, it's going to help out. You're going to learn a lot from that one. And the last thing I want to mention and remind is, what was it I wanted to talk about? Oh yeah, the raffle. For those just tuning in, we're giving out free video consultations every 10 minutes or so. And 10 minutes from now, my assistant's going to announce a new winner. To participate, just like, subscribe, and write consultation. And we'll pick your name at a raffle, and we'll name you so you get to try to schedule a consultation. All right, we'll take the next question. Mohammed asks, hi, can an asylum applicant who has the case still pending adjust status through a green card holder wife? Well, Mohammed, there's a long discussion of this. I've done multiple videos on this. The short answer is it depends. In some places in the country you can, in some other places you can't. And this is because if you have an asylum case pending, most of them take years to get a case. And by that time, your existing status is expired. Now, if you came on a student visa and you're still going to school and you have a student visa, or you came on a work visa and you're still in status, then yeah, you could do that. But if you came on a tourist visa, which expires after 6 months, and you're still here pending your asylum application, some offices, some USCIS offices will allow you to adjust status, some won't. So we got to see what your location is and what the practice is in that USCIS office, whether they'll accept that or not. That's the shortest answer I could give you. Good luck, Mohammed. Paranoid Android on a regular asks, scheduling an interview is a pain. If I request a NIE, that's a waiver of the COVID ban, at a consulate for my second O1, can I just send in my approval plus letter from my employer describing why, what, when? I'm a design director for Revlon. This is embassy based. I don't really handle too many NIEs. It really depends on which embassy you're looking at. They're backed up. You got to contact them and see what their specific process is. Recommendation is just not travel in these kind of cases. But it depends on your embassy, and you have to research to see how they're processing cases, how they like to do it the best. Marlon, thanks for joining again. Kishore says, which address do you email the EAD AP renewal application based on a pending EB adjustment case? Well, go on the form for I-131, and it says mailing locations with a pending adjustment case, and send it to the address there. For the EAD, typically you can send it to the same address, but I just send it to whatever address is on the I-765. So the direct mailing addresses are listed on the USCIS website. You can find them there. I don't have it handy, so you got to look it up there. They have said for EAD, for work permits, you could attach it to any other application, send it to that location, but I'm paranoid about doing that even though they say it. So I just go to the direct filing address for the EAD and the AP and send it to those locations. Sometimes it's the same place, depending on which state you live in, but sometimes it's in a different state. So Haiba says, is the embassy in Islamabad, Pakistan having an interview for immigration? Is it open? Well, they are open. They are processing cases. It's just very slow and very few. I have colleagues that told me in Islamabad, Pakistan, they have had cases done, but it's not like, they're still backed up and they're only slowly doing interviews. Now, they guys, hi, John. I just got my EAD, my work permit, while my I-589 is pending. Thank you for your counsel. God bless you. Thank you, Nadega. I'm glad I could be of help. That's wonderful news. I hope you can get work up and running, your social security number as well, that kind of stuff. Nadega, if you have the time, appreciate it. Just type in JQK Law in Google, and leave a Google review. It could be a line, it could be just be 5 stars, but all that kind of stuff helps me a lot. I appreciate it. But God bless you, and hope your I-589 gets adjudicated quickly in a positive manner. I know those delays are very frustrating, but God bless. Edwin asks, do you know how to apply for a travel document for someone who has TPS in Haiti? Yeah, you have to request advanced parole on TPS and to be able to travel and come back. And that's so you got to request advanced parole and go through the instructions for Form I-131. Sharing's caring. Thank you so much. Thanks for participating and winning the free consultation. I look forward to talking with you, Sharing's caring. Again, just take a screenshot, send it to me, and we'll do a free consultation. We have 3 more left for those just tuning in. Just like, subscribe, and leave a comment saying consultation, and I'll take my assistant will pick one person in about 5 or 6 minutes, and then we got 2 more after that. Do free consultations, a 15-minute video, so we talk about your case. Paranoia Andrew says, thank you as always. God bless you, Paranoia. I hope this situation gets better. Let me talk really quick about what this NIE is. So because of the travel bans due to COVID, to be able to come to the United States, you have to get a special waiver of the COVID ban. And you have to show the embassies that there's some sort of urgent exception that gives you a permission to enter the United States. But so many people are requesting this. I mean, tens of thousands of people. For example, in London, the embassy in London, they said they get numbers. How much are the numbers? They get maybe 8,000 emails a month. Right now, they're getting like 60,000 emails a month coming in. So they're really backed up. Even if you have an emergency situation, it'll take a couple of weeks to get special permission, unless it's really, really, really emergency and you push the issue somehow. I don't even know. So it's pretty catastrophic when it comes to global migration all over the world. But hopefully you'll be able to solve your situation. Mohammed asks, it's the Chatsworth office. Will they let us adjust? Thank you very much. Hi, Mohammed. The LA district, which includes Chatsworth, historically, I haven't had a case like this myself, but I have had colleagues in the last year or so who've said they've had success. But past success is not an indicator of future success. But you have nothing to lose. You have filing fees and potential other denials consequences. But for the most part, maybe worth doing. You should consult with an immigration in private. But I have heard of Chatsworth accepting it. But you never know. You might have a new officer or a new chief that changes the rules. But again, Chatsworth seem to be accepted, but I just can't tell the future. It's an area of law that's not properly designed, so we're getting really weird results, inconsistent results on it. Nadega says, thank you. God bless you. Thanks as well. Thank you. Lottie asks, it's been 1 year. I have a pending asylum, no interview yet. Are the courts open? Yeah, they're open, but as you know, there are 1 million cases backup, 1.5 million maybe case backups. The asylum office, tens of thousands of case backups. Waiting 1 year for an asylum interview is normal. Waiting 3-4 years is normal. So you just got to be patient. Ulua asks, hello, if I divorce my husband and he has a temporary green card, will that be taken away from him? No, it won't be taken away from him. Your husband, if he has a temporary 2-year conditional green card because your marriage is newer, will need to file a Form I-751 removal of conditions, just as you would if you're still married, and then has to, satisfy USCIS that although the marriage is not together anymore, you're divorced, you are, we're still really a couple. It was not a lie. They'll want evidence, they'll want paperwork, they'll interview him, they'll talk with him. But these cases do get approved unless they just don't believe him or something like that. So it is possible for a husband to keep and maintain their green card, eventually get U.S. citizenship. Jassy asks, if a judge offers PD, which is, what's it called? The PD is the permission to, they put your case out, prosecutorial discretion in the individual interview. What should I do? Jassy, that's too case specific. It depends on the whole situation or case, what you're trying to do. That's not something I could talk about here. You need to consult with a private immigration attorney and get their opinion. I don't handle court cases, so I'm not a good resource for that. But this is something you need to talk about in private with an immigration attorney. Giwa asks, good evening. Please, any updates about Essential Act? The reality is don't even look until they say a law is passed. Don't even bother researching. Don't even bother reading. Don't follow the news. It's all just hype and nonsense. Until a bill is passed and the president signs it, there's 50 immigration bills that come out every year, and 99.9% of them don't go anywhere. So whether it's Essential Act or whatever this kind of stuff is, it's just wasting time. Go enjoy your life. Don't think about it. I know you want to think about it because it's going to help you potentially, but that time is going to be wasted because they have no control over it and nothing's probably going to happen. So, spend the time with your family, exercising, having a good meal or something like that. Don't waste it thinking on what's going to happen in Congress or Senate or all that kind of stuff. They're a very unreliable organization to even follow. All right, next question. Okay, well, actually, we have a winner. Our raffle winner is Ululu616. Thank you so much for watching. Ululu, I want you to take a screenshot of wherever you're watching this so I can see your username as being you, and then email it to me at info@jqqlaw.com, and I'll reply with the link so you can schedule through that link a 15-minute free video consultation. We can discuss the case you talked about or anything else in that time. I look forward to talking with you. And speaking of these marriage cases, I do have the ultimate marriage green card guide, the best guide out there, free. Just go to marriageimmigrationlaw.com, download it, check it out. You'll be blown away how much information there is in there for those who don't know if they want an attorney and try to figure out what's going on, all that kind of stuff. Read it and then judge for yourself what you want to do next. But there's videos within that PDF that you can click on that further break things down. It's an encyclopedia of knowledge. You're going to be amazed how much free information is that can help you out. And I hope it does. Just go to marriageimmigrationlaw.com. And for those coming in new, we have 2 more free video consultation raffles. Just watch and like, subscribe, and write consultation in about 10 minutes or so. And then in 20 minutes or so at the end of the show, so 2 more spots, we'll give out free consultations to our winners. My assistant, Kayla, will help out with that. So, all right, let's take the next question. Infinity asks, hi, I've applied for adjustment of status. I came with a B1, B2 visa that will expire in 6 months. So I don't have the rest of your question, but I think I know what you're going to be asking. What happens? You have a green card case pending, and you have a tourist visa that's only 6 months. The green card case is going to take a year probably. What happens in the meantime? Well, they have this thing called an authorized period of stay. Once you're in the United States and you start a green card case, filing form I-485 for adjustment of status, you are in a period of authorized stay until a decision is made on the case. So you can stay here even though the visa expires. Now, it does not guarantee that you won't be sent to immigration court, but realistically, they made a determination, practically speaking, that what is the point of sending you to immigration court if you have a case pending and you're potentially going to get a green card? Let's see what happens. So they, most likely you just wait until, your interview happens or a green card is issued. And if you're denied, then you may be sent to immigration court. Rarely will they come knock at your door looking for you, although it's done, but very, very, very rarely, to a point that it's not something I'm worried about. What typically becomes problematic is while you're waiting for the green card, if you get in a fight, if you drive under the influence of alcohol and the stuff, the police comes in, that's when it becomes problematic. But if you came on a tourist visa and then change your mind, decide to stay and file for adjustment of status, you can stay in the United States until a decision is made. You don't need to maintain status after the I-485 is filed, as long as it's not a frivolous I-485, you filed it properly, there's not other issues. So there's always more we can analyze in the case, but very specifically, do you need to maintain status until a decision is made? No, you just have to have proper status at the time of filing, with some exceptions. For example, if you're married to a U.S. citizen, even if your B1, B2 is expired, you can still file for adjustment of status if you enter lawfully. So there's a lot going on there, but I think I rephrased the question you may have, and I hope that answered it. But thank you for your question, Infinity. Alula asks, we have an interview after 2 years for his 10-year green card. Can he still get his 10-year green card? Alula, let's talk about that private. There's a lot more I need to know. It is possible to still get it, but there's a lot of problems that could come up we have to figure out. D asks, what if I have to file taxes, but still didn't get my EAD and my social security number? Should I apply for the taxpayer identification number? Well, this kind of goes to accounting and CPA kind of stuff. I'm not qualified to give tax guidance, but it's better that you do if you can. Why not? I'm going to leave him at that. Talk with an accountant about that. Whether that affects your immigration case or not depends on what you need this for, what kind of immigration case that you have. Now, a lot of people do get a taxpayer identification number and do file taxes. It's not a bad idea. For certain types of cases, that's useful. But there's a lot going on that I would need to know individually about your case before I could answer that properly. But first and foremost, talk with an accountant about the taxpayer identification number. That's not something that I could properly answer. So, there's a lot in this immigration situation we're going through. I'm getting a lot of questions coming in in particular about DACA. And we don't know what's going to happen with deferred action for child arrivals. There are groups of people who came here as kids, they got special permission to stay here, the program is semi-blocked. We got to see what Congress does, what the new president does about it. The courts are going one way. It's all up in the air. It leads to a lot of stress and tension for the people who and their families who are in this program. But if you have DACA already and you have a chance to get a green card, you definitely should look into it. Some people, have lawful entry. I have people that could get a green card years ago and they haven't. They're married to U.S. citizens, for example. Definitely, if you have DACA, talk with some lawyers and get an idea of what's going on with the whole thing and what options you have. You don't want to be left in the dark. You want to have some good options, or at least if you don't have options, you want to have a qualified person explaining it to you so you know exactly what's going on, so you can make a proper decision for that. Now, D follows up. They asked about filing taxes. They're filing adjustment of status through marriage. Well, if you're married, you got to file marriage filing jointly. You should put your name on there and get a tax ID number. I was talking with a client who's an accountant, says you can't do this or can't do that. But what I see a lot of people do is, and again, it's not accounting advice, go talk to an accountant. They do write their name in there and say no SSN, no social, or something like that, and submit it. Or they do an ITIN, the taxpayer ID number request with the marriage certificate, with the tax return. And it's they're doing a marriage case, having a joint tax return becomes important because it's additional evidence that you're really a couple, both at the adjustment status phase and later on for removal of conditions, even for citizenship. If you're filing for a 3-year citizenship, having the joint address listed on the tax return helps a lot to show that you're a legitimate couple. So that's the thing to do. And if you don't file married on it, you don't mark married, especially even better, married filing jointly. If it's not like that, it becomes more and more problematic, and some officers will hassle you more and more. So it's something we kind of want to be careful of. We want to watch out for in these kind of cases, how the tax returns look. But you got to make sure your spouse makes the proper amount for it too, for the affidavit support. That's something else to be mindful of. Now, the employment authorization document is something that's creating a lot of problems. I'll take this other question, then I'll get to that. Mindy, thank you for asking. Mindy asks, I'm applying for both EB1 and O1. Should my recommend, so EB1 is if you have extraordinary ability in some area and you're applying for a green card, and O1 is similar, but it's for a temporary work visa to work in the United States, but not a green card. And this person, Mindy, is filing for both. Yeah, should my recommendation letter specify which category I'm applying for, or can they just say immigration petition so I can use the same letter for both petitions? The reality is the recommendation letters are about your background and what you do. So they shouldn't even really reference immigration. It has nothing to do with immigration. And the focus should be on who the person it is, how they are qualified to give this recommendation, and secondly, detail how you are qualified specifically to have this commendation. So that's what you should focus on. Now, mind you, I don't file O1s and I stopped doing EB1s. So if you have an immigration attorney, listen to individual counsel. But when it comes to a letter, the point of the recommendation letter is to recommend you as a person, not to discuss any immigration matter. The recommender signing it is not in a place to give immigration opinions and stuff like that. It's not what they're trying to do. They're trying to talk about how great and successful you are. I don't handle these kind of cases anymore, but I have a lot of colleagues that do. Just contact my office and I try to connect you with somebody if you want to consult with an immigration attorney about something like that. So going back to what I was talking about, the EADs, employment authorization documents. You're welcome, Mindy. They're going to be extending it for adjustment of status. We're still seeing delays just getting the employment authorization document in the first place. We are getting faster at getting receipts, much faster, and somewhat faster at getting the biometrics appointments, which were taking forever long. So that's kind of getting things faster to get it. But employment authorization documents, right now I have cases 9 or 10 months, still no EAD. So it's a very, very peculiar thing. Mindy says, that's very helpful. Thank you. You're welcome, Mindy. God bless. Peace for all. I think one of our regulars, I've seen the name before. Hello, if a petitioner for a spousal visa doesn't have work, is she required to send an I-864 signed by the joint sponsor together with the I-130 package, or petitioner can send I-130 package without tax return? So when you're doing a marriage case, you have to include an affidavit of support. And so in this case, the U.S. person doesn't have work. Well, the reality is they still have to submit the form I-864 regardless of whether they're financially supported or not and choosing a joint sponsor. Every petitioner has to submit I-864, and if you have a joint sponsor, they have to do it too. Now, with that petitioner I-864, even when they're not working, they have to submit the most recent tax return or have letters explaining why they did or did not file taxes in the previous 3 years, or explain that why that was appropriate. So even though they're not financially able to support you based on their current income, they still need to file the Form I-864 for an adjustment of status family-based, and they need to submit any tax returns they have. And if they don't, they need to specify why that is, or else the case is going to get an RFE and rejected eventually. Olatami says, thank you, God bless your family. Well, Olatami, thank you so much for the kind words. We do have another raffle winner, Infinity, I think it is. Thank you so much for asking your question. Take a screenshot of wherever you're watching this so I can see your username. Email it to me at info@jqqlaw.com, info@jqqlaw.com, and I'll reply with the link so you can schedule a free 15-minute consultation. We have one more raffle space. In about 10 minutes, we're going to offer that. Please, if you're watching this live, like, subscribe, and leave a comment like consultation. And my assistant Kayla, in about 10 minutes or so, will name one person for me to list so you could get that free video consultation. And if you're doing a green card case, in particular a marriage green card case, download the Ultimate Marriage Green Card Guide to learn what's involved in this process. Go to marriageimmigrationlaw.com and check it out there. If you want to schedule a consultation, fees do apply for consultations. But if you want to schedule a time, just email me at info@jqqlaw.com, info@jqqlaw.com. That's my email, and we could get into the details of your case there. When you email me, briefly describe what your situation is so I have a better idea what's going on, and if it's the type of case my office handles, and we could take it from there. Now, the marriage case is the primary case I focus on. Let me take a Peace for All's question. It kind of goes, Peace for All is saying, same question, so it's a marriage case. They filed an I-130 package. Will it be rejected if it doesn't include income proofs or I-64? I was wondering if that can be sent later. Under Trump's regime, they would be rejected. Under this new regime, under President Biden, they say it won't, but it's always possible. You do not want to send an incomplete application. That's never a good idea, because the reality is there's 1,000 different officers. You never know how each one's going. I could say it's okay, but if they want to reject it, they can, and then we have to pick up the pieces. So it's inappropriate, and I can't even recommend submitting an incomplete package. So if time allows it, wait and get the full thing in order and do that. And Peace for All says, thank you, Afra. You're welcome. God bless you, Peace for All. I wish you the best in your application. Leono Campbell asks, how do I add my kids and my husband's citizenship papers if I send for already and they are back in Jamaica, I'm guessing? I don't understand how to add my kids and my husband's citizenship paper. I don't understand what that means. So you have to be more specific of the immigration benefit you're trying to get. And this is where the confusion comes in a lot of immigration cases. There's a lot going on in these marriage cases. I have a case right now where the couple filed on their own, and they went through the interview, and they were not prepared for the answers, the questions being asked, and didn't answer well. And they got a notice of intent to deny because the answers were inconsistent. And when we went over it, I saw that they had good answers and responses, but they're overwhelmed the interview, couldn't handle it, and they give like mixed answers where the officer didn't understand. And now they want to deny the case, which has catastrophic results. So now we're trying to fight it. We're going to work on building the case. They didn't submit good evidence. They submitted insufficient evidence, inconsistent evidence. They didn't prep the case well. They didn't prep their lives well for what's going on. And so it's just sad to see. The idea is hopefully, this case is easy enough to file on your own, and most people probably do file on their own. But I see the disaster stories, so that's why I recommend everyone to study up, take it very seriously. Don't say this thing like, oh no, we're a real couple, we have nothing to worry about. You're dealing with the government. You're dealing with a blunt instrument. You never know who the person is you're dealing with. So even if you don't hire an attorney, take it very seriously. This is a big deal in your life. The consequences are dire. So you want to go in with your eyes open, really prepared. Don't just say, oh, I'm an American. If the petitioner, I have no arrest history. I have nothing to be afraid of. You're dealing with the government. You never know what kind of errors they're going to make and misunderstandings are going to be. You want to have your best foot forward and be really prepared. So don't go at it with that kind of mindset. It's going to create a lot of problems for you all over the place. And I see it every day. People call me every day with these kind of problems. Now, one note I want to make, I want to do at the beginning, and I want to make sure it gets out there. We'll make a clip of this. It's for Australians. So the country of Australia, unfortunately, because of COVID, they've restricted the movement of their people. Both leaving Australia has gotten very hard. There's like someone's in prison there right now because you can't leave unless without special permission. But also entering is restricted. And they've gone an extra step and put a ban a limitation on even their own citizens from returning to the United States. So right now in America, we have thousands of Australians who came here as tourists. They're here. They come on a program called the Visa Waiver or the ESTA program. And with the ESTA program, they can stay up to 90 days here, and then before 90 days done, they return back home. But a lot of people are getting notified by their airlines that the government, Australia, will not let them return at the intended date, and they're rescheduling their flights past the 90-day mark. So that's terrible because that's automatically going to force them to violate their stay in the United States to create problems. So in these kind of cases, you have to contact the local CBP port where you're probably exiting. CBP is the Customs and Border Protection, and ask them what is the procedure for extending it for 30 days. And then once the 30 days is done, doing another extension. Some will help you out there. Some will say contact USCIS about this program. But you need to, if you're feeling this happening, as soon as possible, do it. Don't do it the last day. Don't do it a week before. Try to at least a month before the expiration, the 90 days are up, to contact first CBP at your local, see if they're willing to do it. And if not, then contact USCIS to request this extension. It's going to be a lot of work, a lot of phone calls, a lot of headache, a lot of paperwork, and it's not clear whether it'll be approved. But you got to do it because if you overstay, it's going to have consequences later if you don't get the permission. It's a disaster all around, the fact that Australia is doing this. I can't believe it that a country would do this, especially a Western country. But it's what we're dealing with right now. And, it's so much hassle to fix it, but that's the situation to deal with. We saw this at the beginning of the pandemic as well, when people were afraid to fly and they were requesting these extensions. CBP was doing it, then many of the ports were backing up and saying, no, contact USCIS. So there's a hodgepodge of laws on how this is being done. That's why you have to contact the local port that you're going to be dealing with to see what their procedures are. And if they do it, if not, contact USCIS. You may need an info pass appointment, which are very, very hard to get. It's even hard to get someone on the phone with USCIS. You may be on hold for hours, and they might hang up on you. So it's going to be a really, it's a ruin your vacation. But that's something to be very careful if you're Australian. You want to make sure you try to do the paperwork right, and hopefully you do. But I wanted to share that with our viewers. I know we have a lot of Australians, I have a lot of clients that are Australian, so I'm getting the emails and I'm aware of this disastrous situation. Hopefully this guidance will help you try to solve the situation. All right, so everybody, we had a long show today. We'll take one more questions and maybe one more raffle winner, and then we'll call it a day. Your buddy asked, do you know if there's any delays for DACA renewals? Yes, there is. I mean, DACA renewals itself are usually pretty quick, so I wouldn't say there's delays there. What I'm seeing delays are is advanced parole getting approved for DACA holders. And so that's taking a little longer. But my DACA renewal cases, I don't do too many. They usually come back in 2 to 3 or 4 months is normal. USCIS got overwhelmed with all the new DACA filings. So maybe there'll be some delays there. The new DACA filings are seriously delayed, but those are stopped because of the new court order. But that's something that's there. I guess one more last question. Leanne asked, my cousin sent my husband's citizenship papers and she didn't add my kids. How do I go about it? So my cousin sent my husband citizenship papers and she didn't. Sorry, I got to see what's going on. Definitely schedule a consultation in my office and we can review what's going on and take it from there. There's just too much information to know and the sense is not clear. Thank you everyone for joining so much today. I want to thank everybody for joining us. It's always wonderful. We'll be back every Wednesday. We've been doing it for over a year now, 5 p.m. Pacific time. And then we'll do a half an hour time. We'll take your questions, general education questions, and then we'll give out these free video consultation raffles and see who the winners are. We got some questions popping up. Should I take it? We have about a minute or two. Ali said, ask, my son filed adjustment of status for me at the National Benefit Center. If my iPhone 30 will be processed at the center, you have no control over which processing center is going to process your case. It's probably going to be sent somewhere else. Don't worry about it. Just wait for it to get done. At the end of the day, it's your local office who's going to decide. Finley asks, I received an RFE online while checking my status. It says they have sent by mail, but I didn't get it by mail. So I sent a request online. They say I receive it. But, well, it's all you can do is tell them you didn't get it. So if they want to deny your case, you say, hey, I let you know I didn't get it. That's all you can do. That's why it's good to have a lawyer, because the attorney also gets a copy of everything. So there's a backup there. Hopefully RFE is not something too serious. Our winner is actually going to be your buddy. Thank you so much for asking questions. Your buddy X3, please take a screenshot of wherever you're watching this so I know your username is you. And then we could have a private video consultation to talk about it in more detail. For all the other questions, please email me to schedule a private consultation. My email is info@jqqlaw.com. We'll schedule a time there. And you email me, briefly explain what your question is about so I can see if it's something my office handles, and I'll follow up with the costs and information about scheduling a time. Thank you, everybody. God bless, and I'll see you all next week. Bye-bye.